This is the In Focus podcast from The Hindu.
Hello and welcome to another edition of the In Focus podcast. I'm your host, G. Sampath. Last week, the Supreme Court recalled its judgment of August 23, 2022, wherein it had struck down certain provisions of the Benami Transactions Prohibition Amendment Act of 2016. Through this 2016 law, the government had amended the original legislation, the Prohibition of Benami Property Transactions Act 1988. The 2016 law had expanded the original law from 9 sections to 72 sections. And in 2016, a three-judge bench led by Chief Justice N.V. Ramana had declared as unconstitutional Sections 3.2 and Section 5 of the 2016 Act. Section 3.2 mandates 3 years of imprisonment for those who had entered into Benami transactions between September 5, 1988 and October 25, 2016. That is, a person could be jailed for a Benami transaction done 28 years before the section even came into existence. The other provision that was struck down, that is Section 5, states that, quote unquote, any property which is subject matter of Benami transaction shall be liable to be confiscated by the central government. So, what was the Supreme Court's reasoning in its 2022 judgment when it struck down these provisions? What is the rationale for the review bench led by Chief Justice Chandrachud to recall the earlier order and refer this case for fresh adjudication? And what is at stake for the general public in this case? We look at this issue in close detail in this episode of In Focus, and joining us today is Amit Pai, advocate on record at the Supreme Court of India. Amit, welcome to In Focus.
Thank you, Sampath.
Great to have you here. And I was wondering to start with, if you can just give us a quick overview of what exactly is a Benami transaction. I know it's very common in India, said to be so, but again, a clear definition and why it's a big concern. Yeah.
It's very simple to understand a Benami transaction because we use it generally in our common parlance, most colloquially as possible. Essentially, Benami transactions are illicit money sometimes is not gotten by the person, or is not illicit money or illicit property is not gotten by people in their own name. They get it in their family's name, somebody else's name, friend's name, etc., etc. That's how the concept of Benami really comes into being. What happens, it's, for example, if a public servant takes a bribe or he takes something, some sort of a property, he takes it in somebody else's name.
So that he is safe from this disproportionate income.
Safe from any sort disproportionate assets. This is just an example. Disproportionate assets, sometimes maybe for taxing purposes, sometimes maybe it is illicit money. So that you don't fall within that framework of the law, where if you were the owner if one was the owner of the property, how the law would have dealt with. So that's the loose understanding of what a Benami transaction is. So to legislate upon this in 1988, we had the Benami Transaction Act, where they said, you're prohibited from having, where they gave the state, that is the appropriate government, the power to confiscate such property. Because obviously, if somebody is having Benami property, one is trying really to skirt the provisions of the law in one way or the other.
Now, what if somebody was to, Benami, if I understand that, in my understanding, it is like you're paying the consideration, but the property goes in somebody else's name, right?
Correct.
So what if the source of the money which is being paid, if it's all legit, it's not black money, okay? It's legitimate money, but you want to buy the property, it's in your son's name or wife's name or whatever. So would that be a problem as well if the money source is legit?
No, certainly not. Certainly not. And that's not the intention. Neither is the act sort of prohibiting such transactions. Right. In fact, one of the sections will say that property which is purchased for the benefit of the wife or the unmarried daughter, this doesn't apply to. This is what the prohibition on Benami, which is subsection 3, that says that the first subsection says that no person shall enter into Benami transactions. However, further says that this will not apply if a person is purchasing property in his wife's name or unmarried daughter's name. Right.
Right.
So So the law really takes care of it.
Okay. No, just one small query before we go to the actual law itself. So now A buys a property in B's name, but A is the one giving the money. What stops? I mean, legally speaking, what stops B from just seizing the property and making it his or her own and basically running away with that property, so to speak?
It doesn't. Nothing stops. But normally, one normally in such transactions, as is spoken by experience, there is a dominant person, and there is another person who is absolutely nowhere close to being a dominant person. The person who is the property holder will be the person who's not the dominant person. So, of course, nothing stops somebody. Suppose I purchase property in your name
Hmm.
and you are registered as the owner. What stops you from claiming ownership? Nothing. You do have such litigation also.
Right, because one keeps hearing of, some politician in some state has some 20, 25 properties, all Benami properties, and how they manage to, keep control of them.
Normally, that man will have his cronies as such, who the properties will be in the name of.
Okay.
And that really some obviously I'm sure it has caused problems to people at different points of time, but that is the exact kind of transaction that you want to nip in the bud, and that's why you have a rather stringent Prohibition Act.
Right. So, Amit, so this we have this 1988 Benami Act, which prohibits all Benami transactions,
Correct.
and it also empowers the government to confiscate. Now, what was the need for the government to come up with this 2016 law?
I suppose one of the things that happened, remember 2016 is also the time of demonetization,
Correct.
because one of the principal thrusts of the government that came in 2014 was to weed out corruption. And perhaps that is why what they did really was expanded rather drastically the scope of what a Benami property was understood to be. It included all sorts of things.
Like what was excluded earlier and what was included?
I'll just give you one or two examples. Just sort of your earlier definition read that a Benami transaction was something that was a transaction where one person paid the consideration for another. Afterwards, after the amendment in 2016, apart from that, it also read property that is held for immediate or future benefit or direct or indirect of a person who has provided the consideration. You see, now just see the difference in the scope. Earlier we said that if I hold in your name, I paid for it and rather you paid for it and I am holding it in your name. Here it says property that is held for immediate or future benefit, direct or indirect of the other person.
What is indirect here? How was it indirect?
It could be anything. Perhaps, one doesn't know. Maybe one could put it as a collateral and run a business in the person's name who's really not shown as the owner. Let's take politician X. You run a business in that particular property using that particular property, and one may maybe put a collateral, maybe get a loan. Ultimate beneficiary indirectly or directly may be me. I may not even be a director. I may be drawing some illicit benefits out of it. Similarly, the other thing that the government tried to sort of close is somebody holding property in a fictitious name, or the owner was not aware or denied the ownership of such property. This was the expanded scope of what a Benami transaction was. So if you look at it, if you just look at the definition in 1988 and 30 years hence in 2016, there is a sea change. Obviously Parliament has seen how the last 30 years or 28 years at that point of time, the experience of the functioning of the act has been, and perhaps made amendments which it thought were suitable to get the act to work at its fullest. Obviously, that's the legislature's prerogative. Now, the problem that it causes is here, and that's where we'll come to Ganpati Dilcom, in a minute. I'll just explain in 1 second the problem. Something that is not defined as Benami transaction in, say, 1990 becomes a Benami transaction in 2016. How does the punitive part of the act work? That's where the problem comes. Have I made myself clear?
Yeah, you're saying this retrospective application of the law.
Exactly. The retrospective or retroactivity of the law. That's where the problem arises.
But the Solicitor General, right, Tushar Mehta, he has argued in court in response to this being pointed out that this judgment has undone 40 years of jurisprudence on whatever Benami and all that. What was the government's argument? Why were they justifying a retroactive punitive measure?
So let me just explain what happens in insofar, and I'm sure everybody knows this. If something is not defined or told to be a criminal activity, can you punish somebody for it? The obvious answer would be no, right? So our constitution makes this a certain protection in Article 20, Clause 3, right? Now, the government's argument is that look, we are not changing anything substantively. The rights of people are not substantively altered. It is only a procedural change as to what falls within Benami. We're making it more clarificatory and a much more clear understanding of what a Benami transaction is. That's what the government's thrust of the argument in Ganpati Realcom is. Therefore, it can apply right from 1988 is what the government is trying to argue.
Can you talk a little bit about this Ganpati Telecom case, like just to give context?
I'll tell you, yes. Yes. The Ganpati Dealcom case is the matter in 2022, where a bench headed by the then Chief Justice Ramana, struck down certain provisions of the Benami Transaction Act, primarily on the ground that they were manifestly arbitrary, and because they were manifestly arbitrary, manifestly arbitrary means they were completely oppressive in nature. They were, the legislature, something capricious, etc., which, affected the rights of the people very, very strongly, because of which these provisions do not match up to the constitutional safeguards that exist in the Constitution. And then the bench went on to squash or rather declare some of the provisions of the Act unconstitutional and therefore cannot now be operative in the law, as a consequence of which the question of retrospective operation or retroactive operation of the amended law came to be answered.
Right. So it also one is this retroactive quality of this law. The other is confiscation of property. What was the debate around this confiscatory power, which was already there in the
Yes,
1988 law as well? Yeah.
yes. Now, so it comes back to the same thing. Suppose there is a property X which may not have fallen within the definition of what a Benami transaction was in, say, 1990. And I'm just putting 1990 as a random date to understand. 2016 amendment, whether after the 2016 amendment came into being, can that property of 1990 fall within the purview of the Act and make itself available for confiscation? That is where the question boils down to. So as we just read, when we were discussing the definition clause, some part of the definition, very minuscule part of the definition remains the same. The remaining part of the definition has seriously been expanded. The fact that it has been expanded, something that was not within the meaning of what meaning of Benami property earlier, prior to 2016, 1990 or 2015, either is the same.
Amit, I just wanted to clarify. I mean, you were talking about expanding the definition. So suppose somebody in 1990 had made a transaction in a fictitious name or used this collateral kind of a thing. They would have been. It would have been not possible to prosecute them under the 1988 Benami law for a Benami transaction. Would they not be amenable for punishment?
I won't put it as simply. I would say is the transaction there would be limited to the definition there. Now the question is ultimately what is the first thing that is going to be argued when we go to court? We are going to court to argue whether this particular transaction falls within the parameters of the definition as it exists then. If it exists, if it falls within that definition, then the act is attractive. If it falls without that definition, then the act is not attractive.
Yeah, but every single aspect of the expanded provisions, it
Yes,
does seem to fall within the original one where somebody else is paying the consideration, whether it is
correct.
fictitious or whatever. It is somebody else paying the consideration. It will fall within the ambit of the 1988 definition.
Except the way I would look at it is the expanded scope. That's why I said, no, this property is held for immediate or future benefit. Now, how do you determine this property is held for immediate or future benefit of another person? Fictitious is one thing, that's one part of it. This property is held for immediate or future benefit or direct or indirect benefit of another person. How would that fall? How would that match up with what the
No,
earlier
how
definition is?
does it? No, I'm sorry, this is coming into some kind of a legal tangle. No, how does it matter whether it is for immediate benefit or future benefit or for whatever benefit, as long as it fits the 1988 definition of consideration being paid by somebody else, property in somebody else's name? That's all which concerns us for it to qualify as a Benami, right? How does it matter what benefit it is?
So it will matter because these are further adding other parameters that the prosecution can call into operation to bring within the meaning of definition. According to me, with the larger definition, a larger number of properties would fall within the meaning of a Benami property.
Okay.
That's where the crux is.
Okay, great. So, why did the review bench decide to recall the previous order then and refer the case for fresh adjudication? What was there? What was Justice Chandrachud's rationale? Yeah.
I'll just tell you what happens. In the Ganapati Dealcom case, the question that arose for consideration was this, and the court has very categorically sort of extracted it in its judgment. It says whether the amended act has a prospective effect. So the question that arose is the prospectivity and retrospectivity of the 2016 amendment when it came to the Benami Transaction Act. Now, what the court seems to have done during the proceedings is tested the constitutional validity. Now, please appreciate these are two different forms or two different types of judicial review. In Ganpati Dealcom, what has arisen is a judgment from some high court as to how to apply the law, whether the law is to be applied in this fashion or in that fashion. The question is not whether the law falls within the test of constitutionality laid down by the constitution or not, because it's very simply put, whatever issue has to be decided has to be, according to me, and generally what is done is it is normally framed, both sides present arguments and assist for or against that proposition, and then the proposition is decided. Here, what the court seems to have done is, while deciding the issue of prospectivity or retrospectivity or retroactivity of the amended act, they seem to have examined or tested the provisions of the Benami Act as against the constitutional safeguards of Article 14, 20, Clause 3, etc. Now, that may not have had a situation where the government would have, or it does not actually, if you run through the judgment also, government is not really arguing, or nobody is arguing that this is valid or invalid. So when those arguments are not there, how can you go ahead and decide the issue of the constitutional validity? And that is the precise argument made by the government in the review. And that is the precise finding of the review court, where the review court says, look, this is the constitutional validity of the provisions was never challenged. And mind you, the constitutional validity of the unamended provisions, not the amended, not the wider definition. The unamended section 3.2, was held to be unconstitutional. Section 5 of the unamended act was held to be unconstitutional and manifestly arbitrary.
When you say unamended act, which act are you referring to?
I'm talking
2016?
of the 1988 Act. Sorry, let me just rephrase. The question before the court was the application of the 2016 amendment. While deciding the application of the 2016 amendment, they went ahead and adjudicated on the validity of the unamended act, which was never, which never arose as a question in the proceeding.
No, but the retroactive effect is only from stemming from the 2016 Act, right? There is no retroactivity in the 1980. So it is indeed referring to the amended Act, right? Not the unamended Act. Only Section 5 refers stems from the unamended Act, which is
Correct. No, but again, the 3 also is punishment, right? 3(2) has the punishment. So the the amended provisions would increase the scope of the punishment also, no? Because it obviously enlarges the scope of Benami transactions. Now, the difficulty which you have is while deciding the issue of retroactivity of the 2016 amendment, how could the court have gone into the issue of constitutional validity? That's what the review court has said, which was the only thing that the government argued. Because if you look at the review, it says, this was an undisputed position that the constitutional validity of these acts were never challenged, were never argued. There were no pleadings to that effect. But the court in its inquiry, judicial inquiry, seems to have done it, which is not normally done. That is what the review court says. Now, and it has put it up for fresh hearing to decide the issue of retrospectivity afresh.
right. So basically, you're saying that the 2022 bench went beyond the purview of the case which came to it.
That's right. And this also does not preclude a fresh writ petition or fresh challenge to the constitutional validity of these acts or these provisions of the unamended act to be brought today. They can very much be brought. The same thing can very much be argued and addressed by the government as to why it is constitutional. Because remember, we have something called presumption of constitutionality. So every time legislature passes an act or a law, okay, when parliament passes an act or a law, it is presumed to be constitutional, right? And therefore, if you look at it, whenever a challenge is brought to any act or any law, very, very rarely, in fact, I can in the recent past think of only one occasion where the courts stay the operation of the act. They never stay the operation of legislation, courts, except for the farm laws, I think very recently where they said, have a hands-off approach. Never. They strike it down subsequently because it is presumed to be constitutional. Remember, Parliament is also a constitutional authority. It's a constitutional body. That's why the courts go on the presumption of constitutionality, whereas this court has examined the question of constitutionality or otherwise without it being
So if
raised.
I understand you correctly, Amit, so even if let's say a law is comes to the Supreme Court or whatever, wherever for a challenge with respect to some provision, like in this case, retroactivity, prospectivity, etc. Unless there is an explicit case made or brought in by a petitioner that it is unconstitutional, the court in its own wisdom cannot say it is unconstitutional, even if it is like at first glance, appears to be unconstitutional. It cannot take such a stance. It's not like a suo moto taking cognizance of something is unconstitutional.
That's right. We when we have law classes, we give an example, of procedural fairness, etc. What is due process? Where we say that if there is a law that says all blue-eyed babies must be killed. Now, can such a law be considered as reasonable? Something like that comes, perhaps the court will say, it should not be. And I think
But
we
that
have
can be
more.
challenged as well, I suppose.
Exactly. We have more faith in the lawyer community. They will definitely bring a challenge to it.
Right. Amazing. Okay. One last question, Amit, before I let you go. So earlier, when you were talking about the challenge, to this law in the 2022 hearings, the government had argued that it was, especially the confiscation of property aspect was basically procedural, and therefore it should be fine. But how is it a procedural and not a punitive measure if you're actually confiscating somebody's property?
Yes, that's where I would argue on the reverse. I'm Of course, I don't appear for the government, so my mindset is on the reverse side. But I would not agree with such an argument. I think this particular argument must be raised again. I certainly believe that these provisions must be challenged in a substantive writ petition, because I would not think that you can say that this is just procedural. The argument seems to be, look, we have just changed the definition, we have just done this. It was already Benami property. We are trying to the confiscation, etc., was already there. Blah blah blah. That's one aspect of it. That's definitely one aspect, and that's definitely a legitimate argument to be made to substantiate, or rather argue the validity of such a provision. But I, not being a government lawyer, may not subscribe to that view.
Great. I think, yeah, thank you so much, Amit. I think that's a lot of clarity there. Really enjoyed the back and forth conversation with you. I'm not by any means, an expert on legal matters, but it was really enjoyable trying to understand this entire case and the two judgments, one recalling the other, and why, it follows a logic which really doesn't come naturally to the common man. When something it might seem to be something, but you have to basically go by the procedure, quote unquote. Thank you so much once again for talking to you.
Thank you very much. Thank you. It was lovely speaking with you.
In Focus will be back soon with analysis of the biggest news issues. In the meantime, you can find our podcast on Spotify, Apple Podcasts, Stitcher, and other platforms. Just search for In Focus by The Hindu. We'll see you soon.